Organized money.
Please like, subscribe, and hit the notification button so that more people can get exposed to organized money. Really appreciate it.
We're going to get into some history on this episode. And, you know, I think history books often try to come up with a great man of history. Like they'll do this big thing on how Roosevelt changed the world or how Donald Trump changed the world or whatever. And they don't look at the little men of history, who actually have a lot to do with how our world is structured. And this episode is about one of the little men.
Yes, as an aspiring little man, I really feel strongly about it. So it's a guy named Lewis Powell, who, I mean, not that little. He was a
Supreme Court justice.
Yeah, Supreme Court justice, right? So, but he was basically a very powerful corporate lawyer who became a Supreme Court justice, and he also wrote a memo, which is sort of widely known among political types. It's called the Powell Memo. And that memo encouraged the big business to start buying politics. This came out in 1973. It was a response to Ralph Nader saying the lefties are too powerful. Big business has to start fighting back.
It came out in 71. Do you want to just
Oh, yeah. Sorry.
I think if you just start with it came out in 1971 and just...
It came out in 1971, and it was a response to Ralph Nader saying that big business has to fight back.
Right. And the way that I always hear about the Powell Memo is that it's about money in politics, and it's about getting sort of rallying the cause, rallying the troops of big business to fight these encroachments on their business and their power. But what's a little less understood is how Powell, after that, 2 months after the Powell Memo is released, he is nominated by Richard Nixon to go onto the Supreme Court. And what's less discussed is how he wasn't just a cheerleader on the sidelines. He was in the arena. He was someone who was actively changing the law and changing the way that the law is structured around corporations and the economy from the inside.
It's about a particular change to antitrust law, right? Unlike the Powell Memo doesn't mention antitrust law, but Lewis Powell on the Supreme Court changed antitrust law in a really fundamental way that unleashed the power of bigness that we see all around us. The Powell Memo was sort of not just a memo to the business community, it was also just a series of life goals for himself.
Exactly.
Right?
Exactly. And so this story that we're going to tell you today is about one of those areas where Powell became this mole, this zealous advocate on the inside. And we're going to talk to someone who knows about that and someone who's writing now, journalist writing now about the implications of what Powell wrought in the 70s in the present day. So we have David Seligman. He's the executive director of Toward Justice, a nonprofit legal organization that defends worker rights in Colorado and across the country. And we're also going to talk to Luke Goldstein, staff writer with The Lever, who before that worked with me as a writing fellow at the American Prospect. All right, David Seligman and Luke Goldstein, welcome to Organized Money. Thanks for being here.
It's great to be here. Thank you for having us.
So
thanks for having us on.
Excited for this conversation. A lot of people, I think, in our world kind of focus on the role of Robert Bork, maybe other law professors, even the entire Chicago school, when talking about what changed in antitrust in the 70s and 80s. But Lewis Powell was kind of the man in the arena. He was the man at the Supreme Court that implemented some of these theories and ideologies. David, could you tell us about his career and how he reached the court?
So I mean, Lewis Powell was a corporate attorney for many decades. He was not particularly well known in fancy, prestigious legal circles. He became prominent, and I should say, I mean, Luke, you might be in a better position to sort of chime in here on some of the Lewis Powell history, but I should say Lewis Powell became extremely prominent in conservative legal circles when he published what is now famously known as the Powell Memo in the early 1970s, which highlighted a sort of new strategy for corporate America to use the law and to dominate our democracy and our marketplace.
Yeah, and I think it's great
Then
that he was a Philip Morris board member. So we're all
that's
living
right.
with the choices of a tobacco lawyer. I
That's
love
right.
that
That's right.
aspect of it.
Well, so okay, so Powell, this very important guy. There was this revolution in the law. One of the things I think you might hear from people, at least for me, I didn't know about it. I just thought the world has always been the way that it's been. And we'll get into what, how corporations are structured today and what he did to make that happen. But can you take us, quick snapshot prior to 1973 when everything was wonderful? Tell us
Yeah.
about life was like in the
Yeah.
utopia pre-Powell. No, but like, give us a sense of how things were different so that we can maybe get to where we are today.
Absolutely. So much higher union density. Our marketplace was less dominated by mega corporations. There were many more small businesses. And at that
So
point,
like you'd go on a main street and it would actually be a main street with lots of different types of stores, a butcher, a
absolutely.
baker, candlestick maker kind of thing.
Absolutely, right? And the laws of the New Deal, right? The laws that protect working people had actual meaning in people's lives. They were broadly enforced and enforceable, and that meant that a much a middle class that was much healthier than it is today, and it meant a democracy and a marketplace that was much less dominated by corporate power.
Except super racist, right?
To be very clear,
Like
Other
to be
than
also
very
that,
super racist. Let's not
Yes,
with that
absolutely.
the
asterisk.
good old
And not,
days
and yeah,
weren't
yeah,
always good.
exactly.
Yeah. So when I hear about the Powell memo, I largely think about it in terms of money in politics. There's this belief that the Powell memo was beseeching corporations to start spending their corporate treasuries in the political system to get the outcomes that they wanted. That's mostly how I see it discussed. But David, I think you see it as playing a role in something that was happening in parallel, which were these changes to antitrust law and the way that it was approached in the 1970s. So, could you explain the connection between those two things?
Yeah, so the Powell memo called not just for more money in politics from corporations, but a more strategic involvement in our legal and political systems. And to push a specific kind of agenda that would further corporate power. What that meant in antitrust terms broadly, and the Powell memo itself doesn't get too deep into the weeds on this, but it calls for the investment of in amicus briefing that would help to inform judicial decision making. It calls for investments in new kinds of conservative think tanks that would operate within the university system. And really importantly for our purposes here and for how it shaped antitrust, that memo helps to inspire, among others, John Olin to invest a huge swaths of money in the University of Chicago and the Chicago School of Law and Economics, which then, shaped antitrust law for the next half a century.
One of the things I think I love about the story of, this critical memo that went to business people and these weird people that we haven't really heard of, John Olin and Lewis Powell, and, I mean, is that it's a sort of shadow legislative process. Like it's kind of like it's where stuff is written and done that we don't see, right? These debates that are happening in the business community. And then we have these very technical terms, which are super important and structure our world, but nobody knows what they mean. Or at least there's a coded language that lawyers can use to talk about very important things that doesn't give the game away to normal people. And one of those is something called a vertical restraint, which I've looked at antitrust for years. I still have trouble understanding what that is, but it's super important. I know that because it's the first thing that Aaron Director and Robert Bork and all these important people went after. So what is a vertical restraint? What does it mean?
Give us a good example of a vertical restraint in a way that can really hit home.
Thanks, David. I owe uh, I mean, some of this I owe to you for opening my eyes to this, but this fall, my dad had a bad brain bleed. He's in the hospital, and
Mm,
he couldn't get saline solution, right? Because the hospital didn't have any. This is November 2024, and
mm.
biggest hospital in Colorado doesn't have access to like water with salt in it. It's freaking ridiculous. So they're feeding him these like sodium tabs that make him nauseous, and he can't keep them down, and it's getting dangerous, right? It was actually right around that time. It was in the hospital, I remember, with my dad when I saw an interview with you on More Perfect Union which was about how the we were losing our like supply of saline across the country was endangered because Baxter, which is one of the big suppliers of the biggest producer of saline, I think, in the country, and is based in North Carolina, its production facilities had been damaged by the hurricane. You may ask, well, how does that prevent hospitals from just going out and buying their own saline? I mean, surely you can buy saline everywhere. It's just salt and water. Turns out that there's these middlemen, group purchasing organizations that set up contracts with hospitals that basically require the hospital, if they're going to purchase saline from a specific producer, in this case, Baxter, right? So, my dad can't get saline solution, not because saline solution is particularly hard to make or produce. He can't get saline solution because of a vertical restraint. And I've got my father there, literally puking in a bed because of a vertical restraint. Like that, those are the kind of stakes. That's what we're talking about here. Our antitrust
Yeah.
laws should have something to say about that.
So the hospital just has to buy, if they're going to buy salt water, they have to buy it from Baxter. And if Baxter doesn't have it, too bad.
Yeah, Baxter doesn't have it too bad.
That's
So
that's a vertical restraint. I like that's a good example.
broadly, a vertical restraint is a restraint imposed by a more powerful firm, very often a more powerful firm and a less powerful firm along the sort of vertical axis of the marketplace. So it's manufacturers to distributors, it's franchisors to
So
franchisees.
it's like a contract.
It takes the form of a contract, almost
Okay.
almost always, right? The ways in which a more powerful entity coerces, a less powerful one is often how we see it. You're totally right. It contrasts with what we call horizontal restraints, which are, agreements among contracts or agreements between, competitors along a horizontal axis. I mean, the distinction is in lots of ways totally nonsensical, and explaining it to non-lawyers can make you sound absurd. I mean, one of the first cases that we worked on involving something that could be framed as a vertical restraint was a case involving we filed the first of the franchise no poach cases against Carl's Jr. After Trump's first nominee to be Secretary of Labor, Andrew Puzder, said we didn't need a free market or we didn't need minimum wage laws to protect workers. All we needed was a free market. And then we looked at his franchise agreements, and he had this like no poach provision in there. And I remember talking to, our clients about that case, and our clients had explained how the no poach provision, which prevented people from moving between franchisees, under Carl's.
So wait, so if you work at Carl's Jr., a non-compete would say you can't go and work at McDonald's. That's a
No. Yeah. So what this said
no,
was
no. I'm not talking about no poach. I'm saying a non-compete says if you work at
yes,
Carl's Jr., you can't go work at the McDonald's across the street.
yes.
A no poach is when like that McDonald's tries to hire an employee at a rival like a Carl's Jr. And then also what you're talking about now is that rival Carl's Jr.'s can't hire within the Carl's Jr. world. Is that right?
That's right. So that's what we
Okay. All
discovered,
right.
in 2017 in, Andrew Puzder's company, Carl Jr.'s, in their franchise agreements, right? They said that franchisees couldn't hire away each other's mid-level managers, like the people that help to operate the Carl's Jr. stores. And at first blush, uh, that restraint could look like a vertical restraint, right? The franchisor, in this case, Carl's Jr., telling its franchisees something about how they're supposed to operate. And As opposed to a horizontal restraint, which would be a restraint between two employers, an agreement not to hire each other's workers. And we'll get into this, but the law treats vertical restraints very differently from horizontal restraints. And I'll never forget explaining to my clients that our case could hinge on that kind of distinction. And we discovered that Carl's Jr., in fact, owned lots of the restaurants, or a certain percentage of the restaurants. So Carl's Jr., the franchisor, was also an owner of some of the restaurants. In other words, it was competing along the horizontal. And that's what allowed us to plead that this was, in fact, not a vertical restraint imposed by the franchisor, but a horizontal one, right? An agreement that Carl's Jr. was entering into with franchisees when Carl's Jr. was also operating along the horizontal. And you explain that to like the average person, and they're like, what the hell is the freaking difference? Like if Carl's Jr. owns any restaurants, what's the difference between vertical and horizontal? But so much in our law hinges on that.
So just to draw this out for a second, uh, uh, a vertical restraint, like there were all sorts of contracts where a more powerful entity could like say to a less powerful entity, you have to do this, you have to take this sales territory, or you can't negotiate, you have to sell this item if you're selling this other item. Those contracts didn't used to exist, and now they do. And now there are these kind of arbitrary distinctions between these, like the different entities, some called horizontal and some called vertical, and they're treated differently in the courts. And so it's hard to bring cases because of all of this complexity. But the gist is more powerful companies can force less powerful companies to do stuff through contracts that they couldn't before.
It's much easier to do that, and that is in no small part because of
Okay.
Lewis Powell.
Right. So, Luke, you've reported on many of these examples of, I guess, what we would call vertical restraints, everything from non-compete agreements to complaints of people who can't repair their own equipment. And I'm wondering, like, you've talked to people who are in this situation, and do you feel that this is a particularly pernicious kind of practice, that there's this aspect of control that's built into it and coercion that makes it particularly galling to people?
Yeah, well, I mean, I'm learning about some of this history for the first time, and it's really fascinating. My understanding, also at sort of a big picture level, is that these kinds of vertical restraints that dominant firms will impose on suppliers, distributors, enforcing against that was another way of trying to block just vertical integration, right? Like across lines of supply, and markets. And so I think today we see a proliferation of vertical restraints, but sometimes as well, it's easier to see this, that companies have rolled up so many lines of supply, they kind of have vertical restraints within their own
Right.
umbrella companies.
So I
now,
remember you, for example, uh, doing a story that talked to doctors during the pandemic who were unable to leave their particular practice and go help people who were suffering from COVID because they were tied down by an employer on where they were supposed to practice, right? And that feels
yeah.
like coercion. That feels like control.
Right. I mean, and it just hurt, it hurt the capacity across the country. You would have shortages in underserved, shortages of, nurses and other physicians, even in underserved areas, and, doctors at hospitals that, didn't have, that many people who are in hospitals. They couldn't go over to the hospital right next door because they had these restrictive covenants in their contracts that the hospital owners were not, willing to, kind of relinquish. And you would, just have this across, various regions in the country, which is where, non-competes would, kind of be the most, restrictive.
Right. Now, I think what's important to explain, like we could bring David back in here, is that prior to, I guess, 1977, all of this was illegal. Like there was something called a per se prohibition on vertical restraints, and the controlling precedent was this court case called Schwinn. And could you just describe, like, what was the state of play before? If you tried to block someone from repairing their own equipment, if you tried to stop a doctor from practicing in a different part of the country because you're the employer and you don't want him to do that, all of these things, how were they prohibited under the controlling Supreme Court precedent?
Yeah, and I should just say that it's lots of contracts can be framed as vertical restraints, just about all of them, right? So it's not that like all vertical restraints were per se prohibited, but
What's an example of a contract that is fine that's vertical restraint?
um I mean, like any sort of any sort of like sales and distribution contract, that there are could be framed as a vertical restraint. And in fact, non-compete clauses that, as we've just said, are a form of a vertical restraint. And it's not that they were, pre-1977 in all cases per se illegal, but lots of categories of non-competes, the ones that lots of categories of vertical restraints, many of the ones that we find most problematic were subject to per se treatment, right? Because the law recognized that if you were using vertical restraints, as you just said, David, if you were using vertical restraints to coerce and control, that was something that antitrust law was concerned about, right? Coercion and control, as opposed to now, much of the focus of antitrust is on collusion. So the restraint at issue in Schwinn was a restraint that focused on limiting the territories in which retailers or distributors could sell goods. Vertical restraint imposed in that case by a manufacturer, and Schwinn declared that that kind of restraint was per se illegal. Like you didn't have to examine whether there were pro-competitive justifications. You didn't have to do some sort of complicated, market definition analysis. It was illegal. It was harmful. It, undermined the independence of businesses, in that case, the distributors or retailers, to sell their goods however they wished.
So, like a franchisor who wanted to sell a Schwinn bicycle could not sell it unless under the conditions that were imposed by Schwinn, and that was the problem. That was the thing that needed to that the court said was actually prohibited.
Yes.
Okay.
As
And then
per se
along
matter.
comes this other case, this Continental TV versus GT Sylvania. So let's set the scene on that. So Sylvania is a television manufacturer. Continental is a retailer, a franchise retailer. Sylvania is not selling a lot of TVs. They're losing market share. And so they change how they want to sell TVs. And they do so in a way that restricts Continental, right? So what is the dispute here?
The dispute in this case is about where Continental can sell its TVs. And if I recall correctly, Continental, there was a dispute involving Sylvania. Sylvania had contracted with another franchise to sell in an area that Continental, or was competing with Continental. Continental was pissed off about that. Continental decided that Continental's told Sylvania that it wanted to go sell goods to sell the TVs in Sacramento. So it started doing that, and that led to the dispute.
Got it. So I guess so. Continental tried to open a store in Sacramento, and Sylvania thought it had enough outlets there, so it like crashed the line of credit that it gave to Continental, and then Continental withheld payments, and Sylvania terminated its franchise agreement, and here we are. So, based on what you just said about Schwinn, this sounds like an easy case, right? Sylvania is essentially doing the same thing that Schwinn was, right? And that's a vertical restraint, which under the precedent is just a violation. Yeah.
That's right. Now, the Ninth Circuit in that case actually decided that Schwinn didn't apply on all fours, right? And distinguished Schwinn from this case and held that it didn't apply because it wasn't in that Sylvania or Continental wasn't restrained from selling to any particular person or business, but rather just based on territory. But this is yeah, it's a classic vertical restraint, and most importantly, I mean, Schwinn had just been decided 10 years earlier, and there had been a long line of precedent over the prior decades, right, that said that antitrust was concerned with the independence of business people to make decisions for themselves about how to sell their stuff. Um,
Right.
and there was no circuit split here. It was a relatively straightforward case, and not one in which not creating the sort of like the sort of conventional opportunities for court to revisit some of its precedent, especially when that precedent had derived from a long line of antitrust concerns with this kind of problem.
Okay.
Can you give like an example today of sort of the fruit of this of the GTA Continental decision? Like what, I mean, I know that right now, one of the things people talk about is how the bicycle industry is just totally consolidated. So it's kind of like that was Schwinn. Schwinn was sort of freeing the bicycle industry. And then this later case wasn't on the bike industry, it was on TVs, but it changed that dynamic. Give me an example of something that is different now and more top down than it probably would have been. Someone using those kinds of restraints that were legalized.
I mean, I think some of the striking and problematic fruits of this relaxing of per se rules involving vertical restraints we see come up in the labor market, actually, right? Because in labor market contexts now, firms can exercise all kinds of control over workers or labor market intermediaries that they would be prohibited from exercising if we had more robust rules involving vertical restraints. To Luke's earlier point, you see vertical restraints. There's sort of parallel between our concern with vertical restraints and our concern with vertical integration. Well, one reason you might not want to vertically integrate a firm, right, is that once you vertically integrate, then under the labor laws, you're responsible for all of those workers. Vertical restraints allow you to exercise a lot of control outside of the firm, outside of your company, in ways that
I'm just confused. I don't understand how this like the case, I guess, for 1977, like what is that selling TVs? What does that have to do today with some companies' control over employees or over like walk me through that.
well, yeah. So I mean, the my favorite example is rideshare, right? Delivery, gig workers, right?
Okay.
So um, gig workers are purportedly independent businesses operating entirely independently. They are according to rideshare companies, they are outside of the firm. They are outside of the rideshare company, and yet those companies exercise all kinds of control and coerce those drivers in
Mhm.
all kinds of ways. There's constant surveillance. There's all kinds of other contractual controls. Most interestingly, and not to complicate issues here too much, but most importantly, from our perspective, and my organization has litigated uh, this case in California. The rideshare companies or other gig companies fix prices across purportedly independent drivers, right? So,
Right.
Uber drivers don't have a lot of control over how to set their prices. That is a understood in sort of antitrust firms terms. We think about that as a vertical price restraint. That is a vertical restraint from the gig company, the dominant company, across less powerful workers on the vertical axis about what they charge customers, right? And that is the kind of thing that should be prohibited and would have been prohibited under federal law, we say.
So just to fit, and then we can get into Powell and how what he did. But so what you're saying is, without this line of cases that legalize these forms of contracts, say a rideshare driver today, Uber driver, whatever, they would either be a direct employee of Uber with a paycheck and everything, or they would be able to set their own prices and control their own sort of terms. Is it like of service? Is that kind of a world where Schwinn is still in effect? Is that kind of what the world looks like?
Yeah, they would
Okay.
have either they would be inside the firm or they would have
Hmm.
lots more independence and freedom, right? That's the fundamental choice that
Okay.
our labor laws combined with our antitrust laws would put big dominant firms to. You got to choose, right? You either bring them into the firm and then you're responsible to them under labor and employment laws, right?
I
Or
see.
you can't exercise this kind of control outside of the firm.
And Luke, I know you've written about this in terms of antitrust and labor, sort of this nexus point, and particularly misclassification with respect to rideshare workers or with respect to warehouse workers or things of that nature. And I think there's a sense, correct me if I'm wrong, that workers are just sort of more resigned to this. That they don't know this history, obviously, and we're in a place where, oh yeah, there's it's certainly illegal, and we're going to fight the idea that workers are misclassified, but employers are doing it all the time.
Well, yeah, I mean, there's a real bind here. I think Amazon is also probably the best example here for their last mile deliveries, where they contract out to delivery service
Right,
providers, DSPs, right? Even though all those drivers wear Amazon vests, their
right,
terms are dictated by Amazon directly through this vertical restraint relationship, all the way down to like very weird biometric, data, and there's all kinds of surveillance, but as well as wages. And in the Amazon's case, I think in particular, people will be able to connect the story directly that this is the biggest hurdle for organizing Amazon delivery drivers, because there have been several cases. One was in Southern California where one of those contract companies with Amazon DSP, their drivers organized, and then Amazon just cut the contract,
right.
and got another DSP. So part of this is also, a way to union bust. And I think that's, yeah, I mean, that's the big challenge for workers who are on the other end of one of these vertical restraint relationships.
Great.
Yeah, that is a non-price vertical restraint. Amazon's got a restraint here that says written or unwritten that says if you unionize, if your DSP unionizes, we cut the contract. That's prohibited under our relationship with you, right?
Yeah.
And what's problematic about that, right, is that like, if Amazon were the direct employer and you fired people for unionizing, then, you'd be liable under the National Labor Relations Act. Here, Amazon tries to avoid that through this fishering relationship and a vertical restraint.
Okay. So I want to go back to
What?
how
Wait. Can
this.
I just? So I want to pull this out of the labor context because the labor context is important, but it's not like that's the only place where this affects things, right? So if you're a farmer, right, Monsanto is going to say, okay, or I guess Bayer now, there's all of this big patented portfolio of seeds and chemicals, and you have to use it all, right? Or you can't get anything, or they might have restrictive covenants like that. Or pharmacists have to deal with that. Or if you're a supplier to Apple, right, which has a ton of suppliers, some of which are very large, and it imposes really significant restraints so that it can control an entire supply chain. None of that stuff would have been legal, and that's like structuring our whole economy. It's not just structuring like labor relations too, right? So this isn't. I don't mean to be like, oh, it's just labor, because
Yeah.
labor is us. Labor matters. It's about asymmetries of power, and they're throughout the economy, right?
Yes.
I mean, right to repair, I think would be a direct example here as well, right?
Hmm.
Where, you sell an iPhone,
Mhm.
sell a John Deere tractor, right? There would be this whole secondary market for repairing the equipment on that, right? But because of the terms of these contracts, if you're a
Right.
farmer that operates a John Deere tractor, you can't just fix it yourself or get an independent repairman to do it. You have to get a John Deere service person to come to your farm and do that. Same with, getting an iPhone fix. You got to go to,
Yeah.
the Genius Bar.
It's funny because Howard Lutnick this week talked about how the way that we're going to build this new labor force in America is that we're going to build an army of mechanics to fix Apple machines that actually assemble iPhones and material like that, when that would be probably proprietary and very high price.
But this is a great point, Dave. It's like there is so much that is so locked down, and we assume that's just how things are. But what you guys are saying is this is just a legal arrangement that's relatively new.
Totally.
Yeah, and I think it's important to get into how this actually happened and how Lewis Powell was really a very primary and active, zealous kind of advocate for this. So this Sylvania case that we were talking about, it gets appealed to the Supreme Court. And the way the Supreme Court works is, a case goes up to them and they decide whether or not to take it. And that's a thing called cert or certiorari, but cert is usually what it's called. And you have to get 4 members of the court to say, yes, we'll take the case. And as I understand it, when this case, Sylvania, initially comes up, there are only 3 people who want to take the case. And Powell doesn't take that no for an answer. So, David, tell us how Powell sort of becomes this advocate, like, no, we have to hear this case because we have to change this law.
It's sort of amazing. I mean, you can read Lewis Powell's papers online, including his Supreme Court papers. It's amazing to see in this sort of set of notes and memos that he's sending to his colleagues on the court, really trying to wear them down, doing anything he can to try to get enough votes to take this up as a vehicle for what he wants to do, right? Which is overturning Schwinn. He wants to use this case as an opportunity to reshape the law of vertical restraints, which he's ultimately able to accomplish. But when it comes into the door, I mean, the Supreme Court is a court of limited jurisdiction. There's no circuit split here. It's not like courts have come out different ways. The Ninth Circuit opinion, if you read it, is super technical. It distinguishes Schwinn on grounds that don't make a whole lot of sense. This case should never have come up to the Supreme Court, and it was because Powell really wore down his colleagues. He even said he threatened to what we would call dissent from a denial of the cert petition, which would be extremely unusual. Like, basically, I'll cry and scream and throw a fit here by dissenting, unless we take this case, unless we accept Sylvania as a vehicle for ultimately doing what they did, which is overturning Schwinn.
So this guy who's comes out of the corporate world basically lobbies for this case, and he wears down his colleagues, and they're like, fine, okay, sure. And the lobbying works, and the Supreme Court takes the case, and then Powell doesn't stop lobbying, right? Like he's now lobbying, instead of on taking the case, he's lobbying to get a particular result, right? So tell us about that.
The particular result that Powell wants in this case is a sweeping overruling of Schwinn, not a cabining of Schwinn, not the kind of narrow analysis that the Ninth Circuit, the lower court, had done. He wants a sweeping overruling of Schwinn, and something that says, which is ultimately what he got, an opinion that says, look, we value what he calls interbrand competition above all else. And that means, we are going to look the other way when it comes to restraints on intra-brand competition, meaning, competition among the retailers selling these TVs under the brand, right? All we really care about here is competition among, the sellers of different TVs, right? We don't give a crap about TVs within the same brand. That's his prior and what he wanted to accomplish in taking this case, and ultimately what he was able to accomplish in convincing the court to overrule Schwinn.
No, go ahead.
No, you go.
And my understanding is he tells Potter Stewart, I think it's Potter Stewart, or maybe Potter Stewart is the one who initially takes the case, but he tells his colleagues, no, you can't do this technically. We have to be maximal here. We have to overrule it. So how does he sort of convince judges who, his fellow justices who have just as much power as him, who are reluctant initially, at least, to go as far as Powell wants? Like, how does he break them down?
Through and it's not just that the his fellow justices. It's also really interesting to read Powell's memos back and forth with his law clerk who's drafting this opinion, right? There's a sort of persistent effort to wear them down with this with a story about how Schwinn and the sort of their vertical restraint law more generally is fundamentally antithetical to a certain view of what makes for an efficient marketplace. And that's really fundamentally what the court should be doing. This is dangerous. It's like restraining the free market. It is our job to shape antitrust law to be consistent with a certain specific understanding of the marketplace and how the marketplace should look. Part of what helps them get there and is that this amicus effort on the part of corporate interests. And interestingly, an amicus effort that is inspired in part by the Powell memo from the early 1970s, where he articulates how we need, corporate interests, both through universities and think tanks and on their own, and the Chamber of Commerce, to be pushing legal theory that is rooted in a certain understanding of market efficiency. I'll also say, something that's sort of a theme of a lot of this back and forth is a certain sort of narrow understanding of freedom in the marketplace, right? Whereas before, the court under Schwinn and as Justice White articulates in his concurrence, antitrust law had been concerned with a freedom of independent businessmen to make decisions. That is something that, according to Justice Powell should not be at the foundation of antitrust, and instead we need to make sure that dominant firms operating within a brand, right, within the vertical, that they have the freedom to exercise their power and in the ways that they wish, because
Yeah.
that is consistent with a free marketplace of
Okay.
brand competition.
So this is kind of funny. So he tells the clerk, you're being too fair to Schwinn. Like when he gets the initial draft, he's like, you're being too fair. You need to change that up. And the thing that you said about Amici briefs, this is very funny because he points his clerk toward an Amici that was made by some manufacturing company, or I forget exactly the name of the company, but it was a corporate Amici brief. And so the Powell memo a year before or several years before says, you guys in the business world need to send more amicus briefs to the court so the court knows your perspective and can be shaped by it. And then he's telling his clerk, go read that amicus brief and be shaped by it. So he's like inside, he's this mole inside the court. It's really funny.
And, I think we should, name something that's interesting about that amicus brief. I think he actually refers to it in his memo to his clerk as the Wilmer Cutler Pickering brief. So, which Wilmer Cutler Pickering, a prominent big law firm, based in Boston, now Wilmer Hale, right? One of the most prominent firms in the country, right? Writes this brief on behalf of corporate interests. That becomes the name of the brief, right? And with elevated because of the status of this firm, it would have been very unusual for that firm to be invested in this kind of amicus effort just a decade earlier before the Powell memo, right?
Right.
Which is sort of again, a sort of like striking and weird part of this story.
So I have so many questions, but one of them is, all right, so Powell is one justice. Were the others just sort of like, I mean, I know, he threatened to throw a fit, but whatever. Did they just not care that? I mean, it feels like they just didn't care that much. Like the liberals were focused on, civil rights or, environmental or important questions, but did they just not care? Were they just like, whatever, it's business, we don't care?
Yeah, I mean, I think I do think that in Sylvania, they seem a bit worn down. I mean, I think that there was only I don't have this in front of me now, but I think there's only two dissenters in Sylvania. One of them is Justice Brennan. And then of course there's a concurrence from Justice White. They do feel a bit worn down. I mean, by the time you sort of fast forward through some of like Legion, right, which overrules Dr. Miles and says that vertical price restraints as a general matter are also subject to the rule of reason. That's a hotly contested 5-4 case, right? So that's not to say that like there wasn't pushback along the way, right? But in Sylvania, they were worn down, I think, and in no small part because of this sort of intense lobbying effort, and I think because what Powell was very successful in doing, and you see the echoes of this across the subsequent decades of the court's jurisprudence, is in persuading the court that antitrust laws are a special kind of law, a kind of common law, right? That is not rooted in the statutory language or legislative history, but it's fundamentally rooted in what justices think is best for the world based on like economic literature and expertise. Justice Kennedy says that explicitly in Legion. Like this is a common law statute. That's why we should feel comfortable overruling our precedent. I think that's the vibe, right? Like that Justice Powell in particular helps to instill, again, relying heavily on like the
But
outside.
there seems to be a sense, and we don't get to see any of this because the court is very shrouded, and they don't sort of reveal their internal deliberations in any way. But it does seem like whoever is the most or presents themselves as the most authoritative and is really the most sort of has the most drive on a particular issue does carry the day. I mean, this was a conservative court by then. The justices who ruled in Schwinn, there were only like two or three left. But, Powell really wants this. And so eventually he gets it. And you think of these things as, oh, this is the law, and there are very, very technical processes by which it gets rendered. But this is like lobbying. This is just political lobbying. And Powell is just a determined politician.
100%. I mean, and we see this in a billion different ways all the time, right? And not just in our antitrust cases, but in the Dobbs case, right? I mean, like in all kinds of Supreme Court cases, right? The court and law is a creature of politics, and there's politics happening within the court, right? And culture and the culture of the legal profession outside of the court helps to reinforce those political shifts, right? I don't think it is a sort of incidental here, right? That he's referring to the brief that helps to shape the economic theory as the Wilmer Cutler Pickering brief, right? So the big law, right, which all these justices come up within, right, which help to inform what we think of as valuable and prestigious and authoritative in the legal profession, starts to set out these theories that changes the law, right? We see this in all kinds of ways.
Luke, have you ever tangled with big law? Or you got a thought? Let me hear you.
Well, I was going to go off Matt's question here, actually. So I'm just curious. So Powell knew this was a big decision in Sylvania, right? And we see the long shadow of that decision today. Did America know at the time, or legal scholars, what have you, how big of an impact this was, gonna have?
Let me draw that. So there was something in the margin of his notes on the case that said, quote, Posner, Baxter, Bork, right? to Luke's point, like, what is the significance of that phrase, Posner, Baxter, Bork? Did America know what they were getting into? Because Congress could have acted too. I mean, there's a lot here going on.
It was deny, defend, depose only for the 1970s.
Well, what is Posner, Baxter, Bork? And then did America understand what was happening? And did America agree?
But I mean, that's the Chicago school, right? So what he's saying is like, look, like here are the scholars of the Chicago school, again, funded in.
So Posner is who?
Is Richard Posner from University of Chicago, and Bork of
Bork.
We know
Robert
Bork.
Bork, and then Bill Baxter, who is also. So these are scholars who are like very, pro corporate and believe this philosophy.
And the funny thing is, the one clerk who was writing this case or writing the opinion for Powell studied under Bill Baxter.
Yeah. And I don't know, we don't know for sure, right? Like what went into the selection of that clerk, right? But I think what this case helps to illustrate is the sort of like feedback loop of the legal profession that can help to change, really like totally transform the freaking law in ways that affect all of us all the time, that lead to a place where, the owner of the John Deere tractor has gotta go to John Deere to get his tractor fixed.
So I'm gonna sort of disagree a little bit with the historical narrative here because I have opinions, I have thoughts, I have feelings.
I'm sure of that.
So one of the
I never
things
knew
that's-
that.
Yeah, one of the things that's
News to
happening
me.
really by the 60s and 70s in other adjacent areas, basically areas of money, right, is that liberals just don't care, right? There's just no one's paying attention. They're going to anti-war marches, and they're just like, oh, that's boring, useless stuff. The banking committee, they're doing crappy stuff on the banking committee, and whatever, who cares about any of this stuff? It's just for nerds. And so it's not like the corporate world and the big law types are operating without context. Like it's not like they decided in 1973, oh, it's time to be greedy, right? They just had opposition in, 10 years earlier or 50 or 20 or 30 years earlier. There was political opposition, and the political opposition had disappeared by 1977. I know that by the early 80s, when Reagan got rid of most antitrust enforcement, it's not like there was a huge backlash. There was a big backlash when he fired the air traffic controllers and did a bunch of stuff on unions. It wasn't true for antitrust. Nobody thought that antitrust was like, everybody thought that it was the Baxter, Posner, Bork. That was cool. It was even cool among liberals. Like it was even cool among sort of Ralph Nader types. So I just kind of wanted to put that in there. What is the ruling? So Luke, you seem eager to speak. Say something.
No, this is the legacy of kind of the Watergate generation of political leaders, right? I mean, that's sort of my general understanding of how we got to that period from there.
What have you read? Gigantic
70s.
or something? How would you
Was
even
that
know
in
No,
that?
but
there?
it's like
I don't know.
it's like, do we have we have no experience of like liberals and Democrats being crappy on stuff? Like that's completely unthinkable. It's not like, I mean, it was happening then too, right? Except it was it was a different context where there wasn't even any noise about
You're talking
it.
about a neglect, really. And
Like
and
they
Powell
weren't.
capitalized on that, right? Because what he was mounting, I mean, I don't know every sort of history of the Powell memo, but it seems to me that he was saying, look, business community, there's some ground here that we can cover. The Powell memo was reaction to Naderism and what Nader was doing in a lot of respects to constrain certain businesses. But I do think there was a subtext that Powell was saying, look, business community, you guys have a lot of money and you can have a lot of power, and it's wide open to you. And part of that is because the liberal sort of infrastructure was turned in other directions.
But
Totally.
also, like, Continental is a business. So is Sylvania. This was a dispute among businesses, right?
Yeah.
So it's like, this is a specific vision of how to do business. It's not like this is just like, oh, the business community won, right? Like these are different businesses that were fighting each other. And there were a lot of businesses that didn't want this change. This was an ideological revolution from a certain corner of the world.
Right.
Right.
I mean, who asked for the Powell memo? It's the Chamber of Commerce.
Right.
I mean, this is from a top down, like the conglomerates, the really big, large businesses wanting to impose their will on the structure of our economy.
So what is the ruling? What does the ruling ultimately say? How are vertical restraints to be judged from this point forward? And then, you talked a little bit about a future case, the Ligon case, but what are some of the other changes that happen to loosen vertical restraints even further? Or does that happen? I mean, is this it? Are we just still relying on Sylvania?
Yeah, so basically there's a whole string of cases over the subsequent decades. Um, and
So it gets worse.
it gets worse, right? Because what Slovenia is about is it's about a specific kind of vertical restraint, like this sort of kind of territorial restriction, right? In theory, it leaves undisturbed. It leaves undisturbed what we call vertical price restraints. So, the kinds of restraints in which, a manufacturer, for example, would tell a distributor at what price they have to sell, goods. But it sort of causes this sort of sea change across the law, in which ultimately vertical price restraints are also held by the court to be subject to what we call the rule of reason. So I do want to. I think it's important that we clarify here that what they're not saying, what the court does not say in Slovenia is we're totally cool with vertical non-price restraints, meaning these kinds of territorial restrictions. They're totally legal. You can do whatever they want. They say that they should be assessed under the rule of reason as opposed to a per se rule. The rule of reason says that we're gonna look at whether this is broadly whether there's a competitive harm here. We're gonna assess that on a case by case basis. And what that means is that plaintiffs bringing antitrust cases under the rule of reason have to demonstrate that there is a competitive harm in the marketplace, and it's that in which that's whatever market is at issue, and that is really freaking hard, and very often it's absolutely impossible. So the we what you effectively have is you shift from a per se rule of illegality, meaning these kinds of vertical restraints are illegal as a matter of law, and you
Mhm.
shift to what becomes an effective principle of legality, meaning that they are okay, right?
Right.
But not because the court says that they're okay in every
Mhm.
circumstance, just because the antitrust laws are so challenging to enforce, especially under a rule of
Yeah.
reason.
So now, Luke, last year we had you at the Google search trial where you were there every day listening to the arguments. I feel like there's some vertical restraints in that were involved in that case. I mean, this was, uh, we're going to essentially rent this space on a browser or on a device, and you can't put in a rival's search function. You can't put in, whether it's in Google search or in other applications. There was also the app cases. Um, but would you see that as kind of a far afield novel application of this theory that was, as David said, effectively legalized in Slovenia?
Yeah, I mean, this is what really first kind of opened my eyes to the issue of and more sort of exclusive, contracts more broadly, but yeah, downstream from vertical restraints. Yeah, I mean, when I was a cub reporter at the American Prospect, very young and naive, I was sent to the Google trial. And I mean, the whole case more or less centered around the the default revenue share agreement that Google had struck with Apple over a decade ago. And Google had used that agreement to crowd out other competitors in search, had enforced it, very aggressively. Um, and we're willing to share billions of dollars in revenue so that when you open an Apple, iPhone from the store and open it up, Google is, the default search engine. And that's how they really had gathered all the traffic that allowed them to hone the search engine. Eventually data that allowed them to dominate in digital advertising. And I mean that contract itself really kind of exposed the whole game in that case and was counter to the perception that Google had built up for years and years that you associate us with search just because we're the best and we just have the best technology. What was at the heart of it was this kind of contract.
So this is, I think so it's kind of like Google was the boss and they get to control. I mean, I watched the trial, some parts of the trial too, and they just have control over with Apple and Google, that deal, both very powerful, but there were a whole bunch of smaller companies that had to do what Google wanted on whatever phone they were making or what. Not even small companies, like Samsung was one of them. Luke, you
Yeah,
looks like you've frozen up, but okay, yeah. Um, so there were the ability of a powerful entity to control
right.
smaller entities or even just big entities that are less powerful is kind of at the heart of a lot of our economic activity. I want to ask, I guess, final sort of the last question, David, for you is a world. Do you see? Let's look at a world without as like without vertical restraints, right? So one example that I saw is that in 1980 or 81, whenever the personal computer came out, the IBM, which was the powerful entity at the time, signed a deal with a small company then called Microsoft with a dash, right? Saying we would like you to make our operating system, which was MS DOS, and because they were afraid of vertical restraint law, they were under an antitrust suit. They said, you can sell this operating system to anyone. You're going to put it on the IBM personal computer, but you can sell it to others as well, right? Which I don't think you would see today. Today, they would
No.
be like, if you want to sell to us, you have to only sell to us. But that's like a vertical sort of a form of a vertical restraint. Um, if we go back to a world where that is possible, right, things will change dramatically. But that does require either change in the Congress can act or the courts could act. They could see things differently. And there has been a revival of antitrust law, Section 2, like monopoly, all these sort of like people saying, look at all this monopolization that's going on. And a lot of the monopolization is coming from these uses of vertical restraints, not all of it. So do you think that courts are starting to look at these practices differently? And could we see a path out of Sylvania in the next, I don't know, 10, 20 years, something like that?
Is there a path out of Sylvania? Absolutely. Right. I'm not sure the courts are going to be the ones alone that are going to take us there. So we saw a revival of a kind of, pre-Sylvania concern with co contracts and vertical restraints and coercion as something the antitrust laws are concerned about. We saw that under the Lena Khan FTC. We saw that in the non-compete rule. We saw that in the Section 5 policy memo, which is concerned about expressly is concerned not only about collusion as a problem of antitrust, right, but also coercion and domination. And really interestingly, we can't, the states have a role to play here too. And I think the states maybe are where most of the action can be happening over the next several years. So now, for example, we brought our case on behalf of Lyft and Uber drivers in California, where under a case called Mayland, price restraints are still per se illegal, right? And the California courts haven't accepted Legion. It is illegal for a dominant firm to tell less dominant independent entities how they should sell their goods or services and at what price they should sell their goods or services. Now, the reason that we weren't able to proceed in that case is because Uber compelled our clients into arbitration, right? So we'll always have the forced arbitration problem here, looming over absolutely everything. But I think the bottom line here is that states are already doing more and can do a lot more. You can set and it's not just about prohibiting certain kinds of vertical restraints like non-compete agreements. We can set different rules of liability that make it easier for us to attack these kinds of coercive practices. The rule of reason can be impossible to get through, but if we set presumptions of illegality, so we say if you've got an exclusive dealing contract, that prevents some downstream entity from doing business with anyone else but you, that's presumptively illegal, right? That's something that states can do and I think should do, and we're already seeing some of those energies. So yeah, I am optimistic that we can get to a world, a sort of pre-Sylvania type world where these kinds of controls exercised through the marketplace by dominant firms via contract are deemed illegal. And I think, but I don't think the courts alone are going to take us there. I
Right.
think it require the aggressive enforcement and policymaking by states.
All right. David Seligman, Executive Director of Toward Justice, and Luke Goldstein, staff writer with The Lever, former writing fellow with the American Prospect. Thank you both for coming on Organized Money.
Hey, thanks for having us on.
Thank you, guys.
Well, and it's interesting that Seligman, that Carl's Jr. case that he was talking about is a huge deal. It kind of cracked open the whole attack on non-competition agreements. I think it was in, like 2013, 2014 when he started. I mean, it was a long time ago at this point. And it's interesting that he sees it from a labor perspective, because what I see, because I don't care about workers. No, I'm just kidding. But because what I see is, there's this broader dynamic, which is everyone, whether it's where you work, whether it's, whether you're through the products you use, or, you run a business, or you write an article and you want to get it through the Google or whatever, everything feels locked down, increasingly locked down. No, you can't do this. Yes, you can do that. Someone bossing you around, telling you like what you can do with your economic life. And it turns out it comes from this law that nobody paid attention to.
Right. And it was this case that wasn't about workers per se. It was about this company, this Continental TV, that just wanted to sell a bunch of TVs and make a lot of money. And they couldn't. They could only do it under certain restrictions that were imposed by this manufacturer. And the story of the next 50 years is the story of taking that little seed and growing it to incorporate, this imposition on workers, imposition on consumers, imposition on small businesses, imposition on people who are trying to make money on platforms, imposition on every sort of part of our economic life.
It is weird. Imposition is right, and I think it's like the boss's rules, right? And what is weird about it, and it's so many implications. I don't think we scratched the surface. But it's hard to explain to people that whole ways that we do business today just used to be illegal, right? And it's not like Congress ever changed the law. Like the courts just kind of like decided stuff, and it's crazy. I think you and I both have two. Like I'm sure you get this a lot. I guess two kind of reactions to antitrust from normal people. One is that feels like the mob. Like a lot of times, like they're like, wait, you're allowed to do that? Like, but the other one is like a sort of sense. Well, of course, that's just how it works. You're allowed to be like the mob.
That's
capitalism, right?
That's capitalism.
That's the other one. Anyway, but both of those are come out of this notion, right? Out of this significant legal change.
And the thing is, it's not capitalism. It's not how capitalism was practiced for a long stretch between, the New Deal and the 1970s. There was another way of figuring this out that was more, regulated and structured, and the government actually had a role to play in structuring these markets. But that changed. Well, and Lewis Powell was a driver of changing that.
Well, I'm going to push back on that a second, because government, either way, contract enforcement is contract enforcement, right? It's like if somebody says to me, here's a bunch of stuff you can use our intellectual property, but you have to do these terms, and I don't follow those terms, they take me to court, and the government enforces that. So it's like, it's not that government became more or less involved. It's just that they just changed the rules so that the big guy.
I guess I'm using government as a substitution for the courts. And in this case, it's the courts who made those rules.
Yes, that's right. And I get I take your point. I'm just being argumentative.
Take it back. I take
it back. I'm sorry.
Thank you.
I'm sorry.
That was great. And we're going to have another one for you. Keep tuning in to Organized Money.
Organized Money.